Hello, and welcome to the Office of the Patriot, where I try to make sense out of the nonsense of the progressive left and rhino right. My name is Myron Ybarra, and I'm your host. Well, we're at the final stretch of this presidential election cycle, and the leftist propaganda and hand-wringing is peaking. And I say this because legacy media talking heads and washed-up political operatives of the Democrat Party are all screaming about the First Amendment and Section 230. Some of them are going as far as saying the quiet stuff out loud, like the First Amendment doesn't allow us, and us being Democrats, to maintain control. And if that's not the silliest and scariest shit you've ever heard, you are not the only one. So, in this episode of Office of the Patriot, I'm going to discuss the First Amendment, and more specifically, how Americans during the age of the internet exercise that right, and how the socialists, disguised as Democrats, want so badly to take the First Amendment away. The internet and social media, the newest and, quite frankly, the most effective information distribution method in the world today. This information distribution system supersedes all previous methods in effectiveness, such as over-air radio and television and cable and print like newspapers and magazines. There's a number of reasons for this, but primarily it's because everybody who has a social media account can act as their own news station or investigator or writer or publisher or editor, and they can do it in real time. That, ladies and gentlemen, makes for a lot of news and information, but it also means that much of the information is going to need to be vetted. But because legacy media like MSNBC, CNN, and the New York Times, in fact, most of the broadcast and print news organizations have jumped in bed with the liberal left, getting unbiased news from these sources is almost impossible. So vetting what news and information you're getting from any source is just a new norm for the consumer. To that end, all the receipts for this presentation are listed in the description section below. And I'm bringing this up because, as I said in the intro, the numbers aren't looking good for the Democrat Party as it relates to their presidential hopeful, Comrade Kamala. So every washed-up politician and bureaucrat is jumping into the fray with a new tact, and that is to convince the American people that free speech is contrary to a constitutional republic, or in their parlance, a democracy. In this first clip, you have moron John Kerry speaking at the WEF regarding the internet and how it should be regulated to avoid misinformation and hate speech. And I'll just let him try to make you a little bit dumber on his own.
And I think the dislike of and anguish over social media is just growing and growing and growing. And it's part of our problem, particularly in democracies, in terms of building consensus around any issue. It's really hard to govern today. You can't, there's no, the referees we used to have to determine what's a fact and what isn't a fact are kind of, been eviscerated to a certain degree. And people go, and that people self-select where they go for their news or for their information. And then you just get into a vicious cycle. So it's really, really hard, much harder to build consensus today than at any time in the 45, 50 years I've been involved in this. And there's a lot of discussion now about how you curb those entities in order to guarantee that you're going to have, some accountability on facts, et cetera. But look, if people go to only one source and the source they go to is sick and, has an agenda and they're putting out disinformation, our First Amendment stands as a major block to the ability to be able to just, hammer it out of existence. So what we need is to win the ground, win the right to govern by hopefully having, winning enough votes that you're free to be able to implement change. Now, obviously, there are some people in our country who are prepared to implement change in other ways, and
So
that's
you're
really
questioning
dangerous.
really if democracy can survive unregulated social media?
I think democracies are very challenged right now and have not proven they can move fast enough or big enough to deal with the challenges that we are facing. And to me, that is part of what this race, this election is all about. Will we break the fever in the United States?
And next, you have that washed-up political operative who, in my opinion, hasn't learned that it was a good time to bow out of politics back in 2016. And that person is Hillary Clinton. In this next video clip, Hillary goes on to talk about Section 230 of the Communications Decency Act, and she believes it needs to be repealed. Now, the reason she wants it to be repealed is not the same reason I would like to have it repealed, or actually, in truth, to be amended. So again, I'll just let her try to make you a little bit dumber by playing the clip.
There should be a lot of things done. We should be, in my view, repealing something called Section 230, which gave platforms on the internet immunity because they were thought to be just pass-throughs, that they shouldn't be judged for the content that is posted. But we now know that that was an overly simple view, that if the platforms, whether it's Facebook or Twitter X or Instagram or TikTok, whatever they are, if they don't moderate and monitor the content, we lose total control. And it's not just the social and psychological effects, it's real harm.
In these videos, both of these Democrat operatives are essentially saying the same thing. The First Amendment and Section 230 give too much power to the people and not enough to government. And when they refer to government, what they're actually saying is the Democrat Party. They've created new buzzwords, and I'm sure you've heard them: misinformation, disinformation, and hate speech. And these buzzwords have become triggers for instituting free speech controls via social media platforms. So let's get into the law of free speech on the internet. Internet service providers, or ISPs for short, and later social media platforms were targets in the very early years of the internet. They were targets for civil suits brought against them for content that was placed on their sites by authorized users. And that would be like people like me and people like you and this channel, Office of the Patriot. There was a growing fear that if some protections were not passed into law, the internet that was in its infancy in the early 90s would falter and die because these suits would kill ISPs, thus killing a whole new revenue source. Further, the internet would never be able to be the virtual soapbox that many people hoped it could be, because ISPs and later social media platforms would be held liable as a result of litigation. So in 1996, the legislature drafted and passed the Communications Decency Act, which contained Section 230. And Section 230 acts as a shield against litigation, or a shield from litigation for social media platforms, but it also limits the First Amendment protections of the people who use these platforms, you and I. Section 230 was worded to shield ISPs and social media platforms from civil liability that could come about as a result of content carried and shared on their platforms that did not originate from them. And that's where the delineation between what a publisher is and what a platform is came from. Now, the premise behind Section 230 actually originated from the 1959 Supreme Court case Smith v. California. And this is where a bookstore owner was found not to be liable for the content of the books he sold in his store, thus defining and delineating the difference between what a distributor is and what a publisher is. And with Section 230, the term distributor is synonymous with platform. And a platform is what is created by ISPs and social media providers for the end user, again, you and I. The virtual public town square. A publisher reviews, edits, and distributes the written word, which makes them as responsible as the writer for the published content. And that's because the publisher has the authority to amend the original content before it's published and made available to the masses. A platform, like a distributor, allows for the trade of information between users without direct intervention of the information being posted. That's not how it's working today, and that's because of the next part of Section 230. because Section 230 also carries additional protections for social media platforms in that it grants them the ability to moderate and remove content from their platforms they view as harmful, vulgar, or threatening, as long as it's done in good faith. And if this doesn't sound like a First Amendment violation waiting to happen, you haven't been paying attention, and it's likely that you're a liberal Democrat. This protection has allowed many of these social media platforms like Google and YouTube and Facebook and Instagram and TikTok to step away from the intended design of 230 and into the realm of publisher, but without having to endure the civil liability of being a publisher. Not a bad gig, right? I mean, think about the power to control what people say to each other, to control what everybody sees, and to remove people, to include their livelihood, from the virtual town square in its entirety, all under the protection of 230. And as I said earlier, the new trigger words like misinformation and disinformation and hate speech, which actually has no legal basis, give social media platforms the authority to remove content they don't like based on the Section 230's generous protections. What's really aggravating about Section 230 is that the Supreme Court has already codified what is and what is not protected speech. With only a few exceptions, mainly surrounding protected and unprotected speech in and on school property, the Supreme Court has found that all speech is protected unless it is to incite imminent lawless action, which was a finding in Brandenburg v. Ohio, or to make or distribute obscene materials, which was the findings in both Roth v. United States and Miller v. California. The Supreme Court has even ruled on speech that it views as protected, like being able to use offensive words and phrases to convey political messages and engage in symbolic speech. In fact, political speech, according to the Supreme Court, is the most protected speech. In many of these circumstances, platforms like Facebook and Twitter and YouTube have used Section 230 to remove not only the speech they don't like, but the writer as well. Take a look at what happened to Steven Crowder. And I can't tell you how many times that guy was demonetized and removed and suspended. And I'm sure there are hundreds like him. Hell, I've been doing this for over 2 years and I've yet to even be monetized. So on the sidebar, if you want to help me out and if you're not subscribed, do me a favor, hit the subscribe button. And if you are subscribed, please take the time to comment. Social media platforms use Section 230 as a bludgeon to silence people that engage in speech on their platforms that is contrary to their own political standing. This is the issue that many conservatives are dealing with today. Most social media platforms have an extreme liberal bias. However, if you do a Google search on the internet for political bias by social media platforms, you'll find that the first 10 plus sites all refer to debunked allegations of bias by social media platforms against who? Conservatives. And why aren't we seeing the same cry from our liberal counterparts? Maybe because the Facebook suspensions and censoring and the YouTube demonetizations and the Twitter bans just aren't happening to them. Today, it appears that in the hands of liberal social media platforms, Section 230 is superseding constitutional case law, and I don't understand why. So, if any of my viewers are constitutional attorneys, I would love to get your thoughts on why there aren't any more First and 14th Amendment violation suits being filed against social media platforms on behalf of users who are being suspended, demonetized, banned, or even shadow banned. To be clear, I'm all for protecting free speech, and Section 230 does that to a degree. However, Section 230 needs to be amended to only allow social media platforms to moderate to the degree that the Supreme Court has already determined what is and what is not protected speech. We should also do away with the absolute protection from civil suits that social media platforms currently enjoy. Until then, no matter where you get your news from, it's going to be up to you to vet the information. And it's also going to be up to you to use the power of your voice, or in the case of social media platforms, your keyboard, to ensure the First Amendment isn't relegated to history. Because if we don't use it, then we will lose it. And this concludes today's episode of Office of the Patriot. If you enjoyed the presentation, please take the time to like, subscribe, and share this channel on your social media. It is appreciated. Also, please take the time to comment. Viewer engagement via comments is a major metric for channel accessibility on virtually all social media platforms: YouTube, Rumble, Twitter, Facebook. And the more people that like and subscribe and comment, the more this channel will come up when social and political content like this is searched for. And as always, have a blessed day and stay safe out there.